Our last topic for common law contracts is discharge and remedies. So when does a party know when the contract ends? When their duties are fulfilled, the rights are received under the contract, or when it's no longer advantageous for a party to continue or fulfill a promise or obligation. What happens in that instance? It's usually deemed a breach of contract when a party doesn't fulfill the promise. If this happens, the other party has several options. We'll talk about that in a minute. But we have discharge and we have remedies. So discharge is the termination of one's obligation under a contract. And there are 4 ways that discharge can happen: when there's a failure of a condition, when there's performance, when the parties agree, and under the operation of law. So for example, you offer to sell me your house for $100,000. I agree to buy your house for $100,000 on the condition that the house is appraised by an expert and the expert estimates the house at $100,000 or more, and you agree. So then the appraiser comes back and it's $90,000. What happens? My obligation to buy the house is discharged because the condition is that it has to come back at $100,000 or more. What could happen? The person selling the house, you selling the house, can offer to sell it for $90,000. So when there is a condition and that condition has to happen and it doesn't, that terminates the obligation or discharges the obligation. I pay you $5,000 for your car to be delivered within 2 days of the payment. I pay you, and the next day you bring me the car. Performance. Fulfillment of one's duty arising under the contract. Discharged. What if the party doesn't fully perform the obligation? What if you don't bring me the car? And we're going to distinguish between complete and substantial performance a lot more in sale of goods. That's when this really takes action. But what happens if someone does not fulfill their obligation? What happens when someone does not fulfill their obligation? They breach the contract, which means there's a failure without legal excuse of a promisor to perform the obligation of a contract. Consider this. Clay sold an apartment building in San Francisco to Montgomery. The building's plumbing did not meet the standards of the city's building code. The contract between Clay and Montgomery provided that Clay would have the building fixed within 6 months. A year later, the repairs had not been made, and the city fined Montgomery the code violation for the violation of the code, and the building's tenants were moving out. Is there a breach of contract? Yes, there is. On whose part? On Clay's part. Clay failed to fix the plumbing. Does Montgomery have to honor the contract? No, he is discharged. What did Montgomery do toward the contract? Nothing. He didn't do anything. So in this instance, we have what's called a material breach. Okay? Clay materially breached the contract. If the failure or deficiency in performance is so central to the contract that it substantially impairs its value and deeply disappoints the reasonable expectations of the promisee would be entitled to terminate the contract and sue for any damages or loss. So back to our last example, Clay failed to fix the plumbing, which was a central term or a central point in the contract. So Montgomery is allowed to terminate the contract, and he's able to sue. What could he possibly get? What could he possibly sue for? Maybe the return of his money on the apartment, or on the apartment building. Maybe he fixes the plumbing. Montgomery fixes the plumbing and seeks reimbursement from Clay. The loss of rent, possibly. But we'll talk about damages more specifically in a moment. So what if a party substantially performs? What is substantial performance? Performance must not vary greatly from the performance promised in the contract to qualify. to be a substantial performance. It must result in substantially the same benefits as those promised in the contract. So consider this. The Longs contract with a construction company to build a house. The contract specifies brand X plasterboard to be used in the construction. The builder cannot obtain brand X. The Longs are on vacation hiking Mount Everest for 2 months and cannot be reached. The builder decides to use brand Y instead, which he knows is identical in quality and durability to brand X. All other aspects of the contract of the construction conform to the contract. Is there a breach of contract? Yes, there's a breach of contract. By who? The builder. What did he do? He deviated from the brand of plasterboard, so that's a breach. But was there substantial performance? Yes, there was substantial performance here. He still built the house under the contract. He just changed the brand of plasterboard. So can the Longs avoid their obligation and be discharged? No, they would still be obligated to pay the builder under the construction contract. What if the plasterboard substitute was an inferior brand in quality, reducing the price of the house by $20,000? Would that change this? Would that be a breach of contract? Yes. By who? The builder. He deviated from the plasterboard, and in this instance, he used an inferior brand, resulting in a reduction of the price. But can the Longs violate their obligation? Was there substantial performance? Performance must not vary greatly from the performance promised in the contract, and here it was to build the house. That's substantial performance, and he built the house. So there still is a duty to pay on the obligation. However, the Longs would be able to sue the builder for any losses. So maybe the reduction in the price of the house. But the Longs would still be obligated because there was substantial performance. We will be discussing performance a lot more under the UCC in the sale of goods. Some contracts require performance to be in satisfaction of another person. Do you see any problems with this? The subject matter, what if the subject matter is personal? It's like take your picture, a portrait, you have artwork done, maybe dental work, maybe tailoring, maybe you get a special suit made, and performance is based on your personal satisfaction. Is there a problem with that? What if you had a real picky person? And the person who just tries to avoid payment so they say they don't like it. Generally, the person expressing dissatisfaction just to avoid payment or otherwise is not acting in good faith. So they must meet their obligation. A party can't just say they're not they don't like it because they are trying to avoid payment. Another way for a discharge of obligations, discharge of the contract, is by agreement. Any contract can be discharged by the parties' agreement. The contract is canceled and the parties return to their positions as if the contract was never entered. I'm going to give you an example that we've used relative to consideration. Is you went to and got an auto loan for $10,000 to get a car. You began paying on the car, but then you lose your job and you've paid $2,000 towards the car and you owe $8,000. And you go to the credit union and the credit union says, give me the car and I'll discharge the $8,000. You guys could do that. You can discharge by agreement. How about I lend you $20,000? You're going to pay me in 2 weeks. It comes to 2 weeks. You don't have $20,000. You have $10,000. And you say, well, do you take $10,000 to satisfy the debt? And I say, sure. Technically, there's no... And then I sue you for the balance. Technically, there's no consideration in the second component of the agreement, which allows me to sue. but we can reach an agreement where you're then released from any suit or liability. That would be the exchange. So by agreement, we can discharge the obligations. And another way, the operation of law. Some contractual duties are discharged by the operation of law, one of those being the statute of limitations. If you're not familiar with the statute of limitations, it's a statute that's setting the maximum time period during which time a certain action can be brought. And it's different from state to state, and it's different from cause of action to cause of action. We're dealing with a breach of contract. So I'm going to tell you, in New York State, the statute of limitations for a breach of contract is 6 years, and it runs from the date of the breach. It doesn't run from the date that the contract was entered into. It runs from the date of the breach. So Joe enters into a contract with credit union for a loan in the amount of $10,000 for a boat on July 1st, 2017. He made payments until he lost his job in the spring of 2018 and stopped paying July 1st, 2018. How long does the credit union have to seek legal recourse against Joe? Well, the statute of limitations runs until July 1st, 2024. They better not wait that long, because they might lose their right. Normally it begins right away. You start getting letters and then an action starts. But it is 6 years from the date of the breach for use the New York statute of limitations, so July 1st, 2024. Another way in which a contract, which an obligation is, a party's obligation is discharged under the operation of law, is when performance is impossible or impracticable. A party is relieved of a duty to perform when those performances become impossible or totally impractical for them to perform. Let's start with impossibility. After a contract has been formed, performance becomes impossible. Now let me give you an example here. What if I come to you and I say, I'm sorry, I just can't do it? Is that impossibility? No, that's not. That's my subjective point of view. The objective point of view is it cannot be done. And it cannot be done by anyone. So for example, I contract with you to deliver goods on a certain date, and you paid for the goods. And I cannot deliver on the due date because of freight car shortages. Can I be discharged as impossible? No, I cannot be. That's like, I'm sorry, I cannot do it. It has to be impossible for anyone to perform. So that's not acceptable, and I'm in breach, especially if you need those goods. What if you needed them for a parade that day? And the day after, you get them the day after, that's too late. So you have to go somewhere else, and it may be more expensive. And guess who would be liable for the difference in the prices? That would be me, and we'll talk about that when we talk about remedies. So it has to be, the key to impossibility, it has to be impossible for anybody. So let's look at some other types of cases here. Contract with me to perform in your ballet because I'm an expert ballet performer and I die 2 weeks before the show. Is that impossible? Yes. Party to a contract dies or becomes incapacitated before a performance. That's going to be impossible. Farm equipment company agrees to sell Mark a specific tractor on its lot and promises to have it ready for pickup on Saturday. On Friday night, a bus veers off the road, smashing it into the tractor, destroying it beyond repair. Does that make it impossible and thereby discharging obligations to perform under the contract? Yes, the specific subject matter of the contract is destroyed. What if only the front light was knocked off of it? If it can be repaired, then that is still going to obligate the parties to perform. How about construction company enters into a contract to build a row of townhouses for uptown homes at a certain location. When the zoning laws are changed to prohibit the construction of residential property at the planned location, the contract becomes impossible to perform. So when there is a change in the law that renders performance illegal, it'll be deemed impossible and the parties will be discharged of their obligations under the contract. Now, impossible versus impractical. Impractical may excuse the duty to perform a contract when it becomes much more difficult or costly due to forces neither party could control at the time of contract formation. Okay? Impossible is it's impossible. If the subject matter is destroyed, the subject matter is destroyed. The contract's impossible. Impractical means it's possible, but very difficult or costly, and neither party could control what the situation at the time of the contract. So let's talk about some examples. Okay, some examples of impractical. The key is the added burden of performing must be extreme and must not have been foreseeable by the parties at the time the contract was made. So several examples include natural disaster, weather-related events, an injury to a performer versus a death of the performer, as in the ballet, disability of a third party that might be involved in the contract. Let's assume that Sarah is a homeowner, enters into a contract with Brian, who's an electrician. Brian is being contracted to do lighting work in Sarah's backyard immediately after entering into the contract, but before performance has begun, a weather-related event occurs that causes significant flooding around Sarah's house. Therefore, Brian is unable to complete the work due to the flooding issues. At that time, it's impractical. Who knows when that can be cleaned up, if it can be cleaned up, or if the project can be put off, but at that time, it's impractical. So to determine impractical, the following elements must be proven. If you're going to use this doctrine as a defense, I do not have a slide on it, so make note of these. 1, an unforeseen event or occurrence. The occurrence must make performance difficult, and the parties must not have been able to foresee that the event would occur. So in the example that I just gave you regarding Sarah and Brian, the unforeseen event was a storm. The occurrence made it difficult for Brian to access Sarah's home because of the flooding, and the parties obviously did not foresee the weather-related event. So in this case, by operation of law, the parties would be discharged of the obligation, or Brian would be discharged of the obligation to perform. So contract remedies, what I like to call show me the money. So if there is a breach of contract and a party sues, what can they get? Well, they get a remedy. And that's the relief given to innocent parties by law or by contract to enforce a right or to prevent a violation of the right or to compensate for the violation of the right. Specifically, remedies could include damages, rescission of the contract, something we call restitution or specific performance. Damages. We have several different types of damages, but what are they? That's money. It's designed to compensate the non-breaching party for the loss of the bargain. It's designed to put the party in the position they were in if the contract had been performed, or in some cases they have not entered into a contract. So let's go through the types of remedies and starting with damages. Damages is a type of remedy. The first one we have is compensatory. This is the most common award. It's a money award equivalent to the actual value of the injuries or damages sustained by the aggrieved party. It's the compensation for the loss of the bargain. So it simply replaced the loss caused. So actual injuries sustained as a direct result of the loss of the bargain. So here's an example. Mary's hired to perform certain services during August for $3,000, but her employer breaches the contract in July and Mary has to go find another job for August, which she does, but is only paid $500. Can she recover? And if so, how much? Was there a breach? Yes. Can she recover? Yes. And what could she recover? The loss she would have had if there wasn't a breach. So in this case, she'd be able to cover. Would she be able to collect $3,000? No, because she got another job and she was paid $500. We're going to talk about mitigating damages in a moment. So she'd be able to recover $2,500, which means she would have gotten the benefit of her bargain, which was $300. So what if she spent money sending out resumes and traveling to interviews, spending money on gas? Would she be able to recover those expenses? Yes, she would. We call those incidental damages. Those are damages directly resulting from the breach. She would have never incurred those expenses had it not been for the breach. So yes, she would be able to collect those. We call those incidental damages. Consequential damages, or they sometimes are called special damages. They compensate for a loss that is not direct or immediate, but is foreseeable. Josie contracts to have a specific item shipped to her, one that she desperately needs to repair her printing press. Josie tells the shipper that she must receive this item by Monday or she will not be able to print her paper and will lose $750. So the item doesn't come Monday. It comes on Tuesday. What can she sue? Is there a breach? Well, there is a breach. Didn't come by Monday. She can probably get her money back for the item that she no longer needs, or maybe she does need it to repair. But if she doesn't need it, she can get the money back. Can she collect the $750? Yes, because it was a consequential damage. The shipper knew. It may not be foreseeable, but he knew and had reason to know. She said it. Punitive damages. This is compensation in excess of actual or consequential damages. Is in excess of actual or consequential damages. It's awarded to punish wrongdoers. We do not see this in breach of contract cases. You see punitive, it's punishment. You see this in tort cases, negligence, products liability. Car blows up and the company knows that if it's hit just right, they blow up and they're sued, they can get punitive damages. Liquidated damages. This is an amount specified in the contract that the parties believe to be reasonable estimate of damages that will result in the event of a breach. So basically, they already determined that if one of the parties breaches, this is how much it's going to cost for the other party to become whole again, or the place that they need to be in the event of the breach. So the parties make their own calculation and they put it right in the contract, and we call that liquidated damages. Some contracts contain something called a penalty, a sum that's named as a punishment for default. If you default on this contract, you're going to pay X amount of dollars. Liquidated damages are enforceable. The courts will not enforce penalties on parties. And to determine whether or not an amount that's stated in a contract is liquidated or enforceable, a court will determine whether the amount was a reasonable estimated amount of potential damages. So that's liquidated damages. You do actually see that a lot in bigger types of contracts for products. So one other concept we got to talk about here. Mitigating the damage. I say this a lot. We have to mitigate the damage. So we have a breach, and there's a determination that damages are owed. And then the next question is, are there any mitigating damages? And what this means is it requires the aggrieved party, who would be the plaintiff or the one who is suing, to have that plaintiff or that party would have to done whatever was reasonable to minimize the damages caused by the defendant. So technically they have a duty but they don't have a duty. Like, they have a duty, or they may not be able to collect, but the duty is on them to not lose any more money. The basic principle of mitigation is that if the plaintiff, through bad faith or unreasonable action or inaction, has failed to prevent or has aggravated her damages, the defendant's not responsible for the increase in loss caused by the plaintiff. So, as I said, it's a duty, but it is referred to that as a rule, but in essence, it only owes a duty to themselves to keep the losses down. So, let's talk about an example of this. There's a lease agreement. You rent an apartment for 1 year. You pay $800 a month. You tell your landlord after 7 months that you lost your job and are moving at the end of month 7. Landlord says, you owe me 5 more months for a total of $4,000. You refuse to pay and you leave. The landlord pays $100 to advertise the apartment and gets it rented for 1 month for the same amount. The landlord sues you for $4,000 for the breach. Can the landlord collect that from you? Do you owe him all that money? No, because he's got a new renter. What he did was he mitigated his damage. He's going to lose 5 more months of rent. He better get somebody in there. He can't just let it sit vacant and say, oh, you owe me $4,000. He has to take action. So he pays $100 to advertise the apartment. He gets it rented after 1 month, and now he's sued you for $4,000. While you may owe $4,000 on paper, he mitigated his damage. So you do owe him. What would you owe him? Compensatory damages of $800, the loss of 1 month rent, and incidental damages of $100 for the advertising. If he sat on his butt and didn't re-rent and then sued you 3 months later for the entire thing, he may be precluded from getting the whole thing. Okay? So mitigating the damage is important. A couple other areas of relief. Rescission. This is an equitable relief, equity law. Rescission. The court cancels the contract and returns the party to their original positions. Another equitable relief that's used often. Specific performance. It's definitely used in real estate a lot. The court orders exact performance that was specified in the contract. So if you buy a piece of property and you've paid, let's say you've paid half of what you owe, and the seller allows you to take hold of the property, but then the contract is not written. It was an oral situation, and you still want the property. In this case, the court will order specific performance. The court orders the exact performance of what was specified in the contract. You may remember from a couple topics ago the promissory estoppel example, where the Hale had a business and he promised his employees that he would pay them $2,000 a month after they've retired, and Sal retires, and for 2 years he gets $2,000 a month, and then Hale, I think the owner, stops paying, and then Sal sues, and based on a promissory estoppel theory, the court ordered specific performance. That's what the court would order, specific performance. You continue to pay on the contract. The court orders exact performance of what was specified in the contract. This happens a lot. This is a very common type of relief. What about Alan? Alan, a 16-year-old, agrees to pay $10,000 to Milo to buy Milo's car. Milo agrees and gives Alan the car with the promise that Alan will pay in 2 days when the bank opens. On day 2, Alan claims he is a minor and affirms the contract, then drives off in Milo's car. Is Milo entitled to his car back? Is he entitled to damages? Milo would be entitled to his car back, because what would happen if the contract's disaffirmed? It doesn't exist. It's voidable. That would be specific performance, where the court orders Milo to Alan to give the car back. Now, if Alan wrecks the car in the meantime, he'd be entitled to damages. And we actually call that restitution because there is no contract, because Alan, who is a minor, has avoided the contract. But then he wrecked Milo's car, so Milo's entitled to something. And we call that type of relief restitution. It's the restitution of goods, property, or funds previously conveyed. It's basically necessary to rescind the contract or prevent unjust enrichment. This is the same type of relief that we give under quasi-contract, when there's a quasi-contract. If you remember the example with the Yale Hospital who paid the medical expenses for the minor and then sues the minor, it's under a theory of quasi-contract that the hospital was unjustly enriched. And the payment would be called restitution. So that is contracts. We will begin next time sales and leases under the UCC, another form of the other form of contracts. And exam 4 will be on shortly.